up next. So, even if you are new to safety, I'm sure you have noticed the words due diligence are always on the tips of our tongues. So, I'm already invested in our first speaker, and I'd like to introduce John Agioritis to speak about what's trending for construction on the legal front. So, as a partner at MLT Aikens, John provides trusted advice and counsel to corporate clients and individuals navigating their way through various types of emergencies, crisis, and incident response, including workplace safety incidents and environmental matters. John leads the firm's occupational health and safety practice group. He is a frequent speaker and commentator in matters of occupational health and safety, labor law, and policy. Speaking to my heart. Thanks for starting us off this morning. Over to you, John.
Thank you so much. I must say, what an honor and pleasure to be speaking to you today. I really enjoy presenting. I love the topic area, and I hope you enjoy the presentation this morning. Um, as I was thinking about this, it's 8:45, and there's nothing like getting your morning started with a bit of what I call instructive tragedy. So maybe what we'll do is get started with a little bit of an intro as to what I'd like to take you through. Today's presentation is going to provide you with an overview of Bill C-45. It's still called Bill C-45, but it was brought into force many years ago in 2004, over, I guess, 20 years ago now. We're also going to talk about the city of Sudbury case, which has implications for prime contractor obligations and owner obligations in Saskatchewan. That's a case I've been studying fairly intensely over the past number of months that since it's been pronounced, because it has some real live implications for many of our clients and many people in your industry, working in a variety of different contexts. So we'll pay some attention to both of those things. But let's just get started with a bit of an overview of criminal negligence, just a bit of a short primer so that you can understand the context here. Criminal negligence and Section 219 and 217.1 of the Criminal Code, you may have heard of that before, but it's a bit different than your standard occupational health and safety obligation. Those typical pieces of legislation when you're dealing with matters under the Saskatchewan Employment Act and regulatory charges which fall there are matters of strict liability. They usually don't involve significant penal consequences, which would involve you going to jail. Though in some contexts they can, but most often the obligation is to either pay a fine, or in some provinces there could be probation associated with things. It also gives you the right to advance a defense of due diligence, and there's no intention element. Criminal liability under criminal negligence is a bit different. The Crown has to prove beyond a reasonable doubt that you either committed an act or failed to do something, and then they also have to prove the mens rea, or the mental element. In the context of criminal negligence, that's basically demonstrating that someone took a marked and substantial departure from the standard of care that's required of a reasonable person in the circumstances. So you might be asking yourselves, okay, well, that's the difference there. There's an intentional component. There could be consequences of losing your liberty. So some pretty big differences. But why did that change in Canada? Prior to Bill C-45 and after the Westray mining disaster, which was the impetus behind the bill, um, it was very difficult to obtain a conviction against anyone in a corporate context unless you were, in fact, the directing mind of the organization. So you effectively needed to be a director of a corporate entity in order to be charged with criminal negligence, or to be charged with, or to charge the corporation with criminal negligence. So these rules effectively make it easier for prosecutors and the government to take action against those who are either senior officers or representative of the organization that might be involved in safety components. That could impact a number of you. And although there hasn't been prosecutions under criminal negligence in this particular province on safety matters, there has been in a number of other provinces, and I'm going to get into that case law. So I suspect that there could be the possibility here. There have been some cases which I've sort of scratched my head as to wondering why they hadn't been prosecuted under criminal negligence provisions, but that's a matter for Crown discretion. So the reasons, like I mentioned, are that Bill C-45, criminal negligence, was brought into play to make it easier for the government to obtain convictions in cases of negligent conduct that goes beyond the standard. So what does the provision say? Everyone's criminally negligent who you either do something or you don't do something that it's your duty to do, and you display a wanton and reckless disregard. That's a pretty significant standard. It involves an offense under the indictable component of the code, so it's a more serious type of an offense. There could be procedural rights that are accorded to you, like a preliminary inquiry in some circumstances. So there's a whole different panoply of rights and issues that arise when criminal negligence comes into play. No limitation for the prosecution of these types of offenses as well. So, like I've indicated on the bullet here, wanton or reckless disregard, more than just carelessness, it requires something a bit more egregious than that. And we'll talk about some cases where that's happened. A marked departure, a marked and substantial departure from the standard of care of a reasonable person that actually causes harm. So you might have criminally negligent behavior that doesn't necessarily cause harm. There's no near miss provision under the code. There's no attempt in this context. So you actually have to cause the harm in order to be charged and prosecuted with it. You have to actually cause either death or a serious injury. So that's a bit of a difference there as well between the two types of legislation. Under the code, when the bill was brought in and the changes were brought in, they changed the definitions to make it more expansive. So the term everyone was amended to include corporations, firms, partnerships, even trade unions for that matter, municipalities and other public bodies. So it applies to organizations generally. And that was a difference back in '04 prior to the legislation being implemented. In the context of organizations, there are representatives as well. So that includes employees, it includes contractors of an org. Like for instance, in the Metron construction case, the project manager was convicted of criminal negligence causing death, and he wasn't even an employee of Metron Construction. He had been contracted to them. So the scope of the provisions is broad. An agent can include someone like an independent contractor as well. So um, a number of parties can be caught by the legislation. Senior officer is another person that's included in the realm of those who are representatives who can be parties to the offense under the criminal code, and that's an individual who might be responsible for managing an important aspect of the organization's activities. For instance, a director, the CEO, chief financial officer. It could be someone who's responsible for health and safety administration in the organization. So again, that can capture a number of people. It's not something that you typically think about. You don't typically go to work every day and think about, okay, well, what are my obligations under the Criminal Code of Canada? But they do exist, and they provide very baseline level of conduct that you must adhere to, or at least surpass, in order to ensure that you're meeting the standards required of you in the community. And another piece that changed in the context of Bill C-45, just as a refresher here, is this provision here, 217.1, which created a duty. And I'm going to flip back and forth to a couple slides here, but this was probably the most important addition that was created, and it indicates that everyone who undertakes or has the authority to direct how another person does work or performs a task is under a legal duty to take reasonable steps to prevent bodily harm to that person. So imagine a supervisor who's got the ability to direct work. It can be even someone further removed than that if you've got the authority to actually direct how a person performs a task. That is the duty that's created by the code. The duty reflects itself, and I'm just going to go backwards here in the charging provision where it says everyone's criminally negligent who, in omitting to do anything, it is their duty to do. Well, the criminal code, Bill C-45, established that duty in the context of 217.1, and it's a broad workplace duty. So that's one of the things that you can be caught with. There are other duties that can arise. That there's no prohibition on a prosecutor using a provincial occupational health and safety duty as forming the relevant component of what you failed or what you should have done in the circumstances to form the basis of a criminal negligence charge against either an organization or a supervisor or an individual who's responsible for causing bodily harm to someone else. So it's just one of the tools in the prosecutorial war chest, so to speak, when it comes to workplace safety. Now, This is Bill C-45. There always were other provisions in the criminal code, and I'd be remiss if I didn't mention them, like safeguarding openings and excavations, ensuring that work conducted over ice is done safely. Those two types of things, and in addition, dealing with explosives if you were in the mining context, that would also be covered. There are some very discrete provisions which relate to duties that might involve criminal negligence or criminal charges in that context, but we're focusing here on specifically criminal negligence. So again, why is it important? Well, you can go to jail. So that's probably the most important piece as an individual. Corporations can't go to jail, but because there's no fines, no limit on the fines, they can be bankrupted. So those are significant obligations that arise and significant repercussions to what happens if you've been charged and convicted with criminal negligence. So for an individual, causing death is potentially life in prison. So a very significant penalty. Causing bodily harm, 10-year maximum, and you can also be charged a fine as well. So there's no limit on that. For corporations, the fines are in the discretion of the court. Again, no fixed maximum, and there's also a 30% surcharge that's applicable on the individual. Some of the considerations that go into determining what number the court is going to impose if there's a penalty would be the cost of the investigation and prosecution. Was there any profit that was received by virtue of skirting your obligations under the legislation? Was there any discipline of the representatives of the company? Was there any restitution that was paid to the victim? Measures to avoid future offenses, like due diligence steps taken after the fact, those kinds of things, and expenditures on that could be important considerations in determining what the ultimate penalty might be. If you don't take any of those, the court can also impose probation consequences, which require you to take a number of steps, including complying with any provision that the court thinks necessary. Some jurisdictions like Alberta do that in the context of the Occupational Health and Safety Act itself under the regulatory measures, and this would be similar, sort of enhanced regulatory supervision, and someone makes an order that you need to implement a safety program. So the the consequences can be stark and they can be serious, and it's an important consideration. One of the questions we get asked is whether a person can be charged with both Bill C-45 or criminal negligence consequences in the criminal code. And the answer is yes, you can be charged with both at the same time. There's no real rules about parallel proceedings. You'd be subject to what's called the Kine-Apple principle. So if you've got the same type of offense that is grounded in both types of proceedings, there might be some ability to obtain a judicial stay if you're convicted on both. That's pretty technical in terms of what could happen, but yes, the answer is yes. Multiple charges from multiple orders of government, you can be dealing with both provincial and criminal code offenses. Okay, so now the meat and potatoes that you all came for. Let's talk about some current cases. Um, Not so current initially. I wanted to just cover off some of the basics. Many of you probably know about Metron construction. This was one of the most formative cases in the area where 4 workers were tragically killed and one was seriously injured in Toronto when they were working on a swing stage scaffolding when the scaffold collapsed. And ultimately, the, the company was charged with criminal negligence. Charges were also laid against the president and project supervisor. The president was able to negotiate a plea arrangement under the OHS Act and was ultimately fined $90,000. There was no prison time for him. The project supervisor, the project manager, Vadim Kaznelson, was not so lucky. He was committed to trial for criminal charges. He survived the fall. He was on the scaffolding, and he was ultimately sentenced to 3.5 years in prison. What had happened effectively that resulted in the prosecution was the fact that the project was behind schedule. It was December the 24th, and the project manager, Mr. Kaznelson, was on site speaking to the foreman, asking him about what was happening on the 12th floor of the construction project, and they were going to head up and inspect the work that was happening. And as they went up, they had 5 other people on the scaffold, plus Mr. Kaznelson. Mr. Kaznelson noticed that there were no lanyards, or there were not enough lanyards for all of the workers who were going to be boarding the scaffolding and going up. And ultimately, he indicated to the foreman, and he said, "Where are the lifelines?" And the supervisor and the foreman himself said, "Don't worry about it." This is almost immediately after the swing stage. They boarded it. Two of them used the lifeline, including Mr. Kaz Nelson. The four others didn't, and they they all fell after the swing stage scaffolding mechanically collapsed. So because he was aware of the fact that there wasn't enough lifelines, and because he was involved in project safety and supervision on the project and had the ability to tell the foreman what to do, the court indicated that he had consciousness of the risk. He adverted to the risk. He knew it was there, but he did nothing about it. So he failed in his duty, and that failure was a failure that fell far below the standard of care in the community, what's called a marked and substantial departure from the standard of a reasonable person. So he was ultimately convicted based on that. Um, when it came time to impose the sentences, the company was charged $200,000, but the Crown appealed, saying that they needed to have more. And in fact, the Court of Appeal agreed with them and imposed a $750,000 fine. Arguments were made that they would bankrupt the corporation, but the Court of Appeal said that's not our concern. Why would we leave a unsafe organization in business just because we're going to bankrupt it? That's not the point here. And of course, Mr. Kaz Nelson strenuously argued that he shouldn't be responsible for this in to the degree which the court indicated, but to no avail. So that was a that was sort of one of the major watershed cases for criminal negligence that made a lot of news. It was something that was very well publicized, and the issue of general deterrence arises when you've got that type of publication. I'm still talking about it because it's a foundational case. There's some other good cases though that fall in the criminal negligence category, not with so many of the significant fines, but just because they can be fairly plain and obvious in your industry. Scrocca is one of them. It was earlier than Metron, but I find it instructive because here you've got a landscape contractor who was crushed to death when a backhoe that his employer was driving failed to stop. Underlining this was the fact that the thing was 30 years old, hadn't received any regular maintenance, had no braking capacity, and they hadn't inspected it in 5 years. So they were charged with criminal negligence causing death. Ultimately, the employer was given a 2-year conditional sentence. This is an individual. That's basically house arrest to be served in the community. So for an early decision, that's an important one, I think. That's a long period of time to be given house arrest and conditions. No indication of any fine, but the idea of not maintaining equipment is something that I find pretty important that can give rise to a criminal negligence prosecution. So I'd be conscious of that if I was in your shoes, and something that something that you need to be aware of. The other one is Stave Lake Quarries. This is a BC decision. I also find it instructive here because of the age of the worker. She was operating a rock hauler. I think it was her second day on the job. She had spent the day earlier, the day prior, with another individual who showed her how to use the truck basically, and then basically left her to her own devices to try and operate it. Um, Underlying all this, she was 22 years old. She had no training, no orientation operating large trucks. There was no license. Um, it was a She understood that you needed to conduct a quick pre-check. She had received some information on air brakes and parking brakes and tire chocks, but um, there weren't any tire chocks to use. And the person who was giving her the training said, "We just put rocks underneath the tires, behind the tires." So the corporate entity um, was ultimately charged. It was her second day of work. She parked the rock hauler on a 10% grade slope using only the air brakes. She didn't engage the parking brakes or chock the tires. The air brakes eventually lost pressure and the hauler started rolling down the slope. She tried to get into the hauler to try and stop it, but the door handle was missing. It had been secured with a bungee cord and she couldn't open it. And then the hauler rolled over her, tragically injuring her and causing her to be crushed under the tire. So, a very unfortunate way to pass. The fact that she hadn't been very well trained, the fact that she was 22 years old, um, the machinery was not in very good condition, ultimately led to a criminal negligence charge in the circumstances. Now, this is not a very big company. They were fined $100,000 plus a victim surcharge of $15,000. But the court basically indicated that criminal negligence is a very serious crime. The consequences must be severe. Society cannot tolerate corporations that employ workers in conditions that are so unsafe that they lead to bodily harm or death. So here, the court took into consideration that prior to this, the company had a good record with OHS or WorkSafe BC. However, needed to take some measures to ensure that the corporation was appropriately sanctioned for its conduct. So that was Stave Lake Quarries. Fast forward to 2023, and the Maritimes have produced some very interesting decisions in the context of some pretty unfortunate facts, but they are instructive because when you look at the overall scheme, you can understand that they're certainly looking to sanction workers. Now, I understand the context in the Maritimes that with respect to the regulatory offenses, like your standard Occupational Health and Safety Act that might exist, the fines are not as high in that in those jurisdictions. So perhaps there's more of an impetus, and I'm surmising here. Perhaps there's more of an impetus to charge into the criminal negligence provisions in those jurisdictions. But we have seen criminal negligence charges in Ontario, the Maritimes, British Columbia, have yet to see anything formal in Saskatchewan or Alberta or Manitoba, but I suspect that might happen in the future. In any event, let's talk about King. So this was a situation in New Brunswick where they were working on a clarifier, and the municipality had hired an organization called Spring Hill Construction to assist with constructing the clarifier. The clarifier was being designed to help process water that was ultimately going to be dumped into a river. So it's basically gray water that's sewage water. And these clarifiers basically separate the sludge, they cleanse the water, it takes it through a system and goes through a UV system and purifies it before it gets deposited into the river. They were working with an empty clarifier, something similar to what you might see here, but not exactly the same in the picture. Um, the the there were 3 or 4 workers working together. 2 were working apart from where the incident happened, and ultimately, the individual Michael Henderson, who was 18 years old, uh, was ultimately asphyxiated underwater, and I can tell you how that happened. So the supervisor had instructed the 2 workers, including the injured worker, Mr. Henderson, to go into a space in the bottom of the large clarifier that was an 8-foot hole and approximately 3.5 feet wide. This 8-foot hole would have received water from a horizontal pipe that was going underneath the clarifier tank. This pipe was not yet operational, but had been trickling water into the hole, and part of the instructions that the workers received from Mr. King was to go into the hole, clean it out, and ensure that you hand up the sludge and all the crud that's at the bottom, so that we can get the hole ready for a concrete pour in order to bring the level of the floor up to where that pipe was. And that pipe protruded; it was about halfway up the 8-foot height. They weren't going to do any of the concrete pour that day. There was some talk about actually doing a leak test to ensure that the concrete was sufficient under the clarifier and with respect to the surrounding area. And the the underlying facts here are that there was no tripod over top of these workers when they went into the hole. There was no plan that was developed to ensure that they could help remove someone if they got trapped down there. One of the workers, whose last name was also King, was working with Mr. Henderson, wouldn't fit down the hole. He in his interviews, I think he indicated that he was too large, so it was Mr. Henderson that volunteered to go down. They really had no mechanism to try and pull anyone out should something happen. Well, at the end of the day, this hole constitutes a confined space. there could be an accumulation of gases that might flow down there, perhaps a lack of oxygen. You never know. You need to take some air samples when you're dealing with confined spaces typically. Most organizations would require a permit to enter a confined space. There was no permit that was executed here. There had been no training on confined space whatsoever for either of these employees, and the supervisor had told him to go in there. Unbeknownst to the two workers that were in the hole was the fact that um, was the fact that the supervisor, Jason King, had been discussing with the city's representative that they were going to perform a leak test. He wasn't sure whether they were going to do it that day or not, but part of what they had been doing prior to this discussion was they were using a pneumatic tube or plug to prevent water trickling into the sump area, that 8-foot hole. So they had plugged it up. They had received the plug from the municipality. They inflated it, and it helped prevent the trickle so that Mr. Henderson could actually do the work at the bottom of the hole. So he's in the hole while the plug is there to prevent the trickle. The job changes, and the supervisor doesn't really tell Henderson or the other Mr. King, who is working with Mr. Henderson, that they were going to begin the leak test. This would have involved thousands of liters of water, basically attaching to that pipe and going through that pipe, but being prevented from going into the sump by virtue of the pneumatic plug. So you better hope that plug holds. And there was no bracing of the plug. They hadn't tied it together or anything else in case it failed or in case it decided to dissipate some air. So you can sort of see the picture that's being painted here. The plug fails, and this is after lunch. They'd come back and they told him to get back in the hole because they still had a little bit of work to do. There's discrepancies as about whether exactly he told him to go in the hole or said, if you don't mind, please take care of that. But in any event, the court finds that the supervisor told the worker to go and do this job. Ultimately, the plug fails. Mr. King is trapped because the plug pins him against the wall of the 3.5-foot opening. And despite frantic and very significant efforts by both the workers that were there and the fire department who came, they could not remove him. So he ultimately drowned and died in that circumstance. The firefighters had to use a sump pump and actually remove the water and then use a knife to puncture a hole in the pneumatic plug. So those are the facts and the circumstances of the case. The supervisor was charged with criminal negligence. I can tell you Spring Hill was also charged, the employer. They ultimately pled guilty to failing to properly train their workers, but the criminal negligence charges were dropped. There was $100,000 penalty. So it was a bursary, actually. It was an alternative measures type of penalty that was imposed against Spring Hill. So Mr. King was facing liberty issues, and so ultimately decided to run the proceeding. The court finds that his actions were a significant contributing factor to Mr. Henderson's death. He put him in the hole and then put water into the system and effectively didn't give him the right to refuse because Mr. Henderson didn't know that they were going to be performing the leak test. At some point in time, thousands of liters of water were being pushed against that pneumatic tube. So he really had no option to even refuse the work, is what the court found. The court also indicated that the supervisor fell far below the standard expected of a reasonable site supervisor on a construction site. And the basis for that was the individual had not read the manual. There was no confined space training program. There was no evacuation plan for the workers that were involved in doing the work in the sump area in the hole. The individual, Mr. Jason King, who was the supervisor, indicated that he was not a reader, and he didn't typically read those types of things. He kind of understood his obligations as a supervisor, being that I'm in charge of safety overall, but he couldn't pinpoint any of the obligations that he had upon himself under the act, and he had not familiarized himself with any of the safety manuals that had been prepared by Spring Hill that would have talked about confined space, that would have talked about the usage of equipment and understanding the fundamental elements of what goes into using equipment, like making sure you follow the manufacturer's guidelines to ensure that things are inflated to the right pressure and that no one works in the same area. So in this case, the pneumatic plug had a decal on it saying, read the manual, and the manual indicated, do not let anyone work in the proximity of the area when the thing is inflated. And there was copious amounts of evidence in this case that indicated, of course, everyone knew you shouldn't be working around an inflated pneumatic tube. Everyone but Mr. Henderson, who was 18. So the in the circumstances, this is a pretty tragic case. Um, Ultimately, the court concludes that these failures to perform even the basic fundamental elements of a supervisor constituted a marked and substantial departure from the minimum standard required by the legislation. And because of the fact that he was the one who instructed him to go in the hole and do the work and didn't follow any of the confined space requirements, there was criminal negligence in the circumstances. Um, I'd say an instructive case for supervisors, an instructive case for employers too. Like, what are the reasonable expectations of a supervisor in the circumstances? Ultimately, it's going to be context dependent. And in this case, the supervisor said, "Look, I didn't know about the requirements in the legislation. I hadn't been properly trained. My company didn't give me training as a supervisor when it made me a supervisor." But the court said that's not enough, and you can't utilize your own ignorance to try and bring down the standard that you must comply to. There are minimal requirements under the law, and as a supervisor, you better find out what they are if you accept that task. So it goes both ways in many contexts, and I think that this case is important for that point as well. Um, Failing to even review specific plans or failing to review the manufacturer's requirements on utilization of equipment can form the basis for some type of negligence. It can surely form the basis for regulatory charges under the provincial regime, but can now also form the basis of criminal negligence. This case is being appealed. So, we take the trial decision for what it's worth. There could be a different result on appeal. There's some discrepancy about the statements being used. So I say this knowing that the result might change. But it's certainly an instructive case, and it's one of those that I think you should, you should know about those. Um, what I will do is I see there are some comments in the chat. I've left about 10 minutes at the end of the presentation to answer some of those, so I'll try and answer them either as I go, but at the end as well, and give you all an opportunity to to ask me questions. Hoyak is another case. Now, Hoyak, one of the questions is common defenses, and this is a case where there was an acquittal, and I thought, okay, another neat case. This actually predates King. Um, Same general territory of Canada in terms of, excuse me, in terms of the Maritimes. This is in Nova Scotia. I would imagine that the circumstances of this particular garage, this was a Your Mechanic auto shop in Nova Scotia, where the owner was basically taking old vehicles, cutting them down for scrap, and then selling the parts. And so that was the type of shop. The evidence was that the shop kind of looked like what you see in the picture, very, very disorganized, full of hazards, and effectively waiting for an accident to happen. So if there was an issue involving an explosion of some kind or some form of gas release, there wasn't really a good means to escape. In this case, they had retrieved a minivan, and there were two workers who were working under Mr. Hoyak, who is the owner, and the owner simply told them, "I'd like you to tear it down because we're going to be, getting rid of the entire vehicle and selling the parts for scrap." And didn't instruct them how to do it. Basically, just said, "Good morning. Just make sure you take care of actually trimming down the vehicle and stripping it down." Um, Ultimately, they were removing the gas tank, and the gas tank was affixed with these metal straps. Instead of using a screwdriver or any kind of a snipping tool, one of the workers, who was a very experienced mechanic and a red seal mechanic, decided he was going to use an acetylene torch to actually remove the straps. And there was an indication by an expert who looked at the actual cut that said that it was in fact cut with what appeared to be a torch. The evidence showed no flashback arresters between the torch and the fuel source. There was excess garbage and preventing escape. They weren't even using a hoist. to actually elevate the vehicle and work underneath it. And you can understand where this is going. When I think acetylene torch and gas tank, I think trouble. But I'm not so sure that these two workers did. Ultimately, he used it. There was an explosion. He suffered significant burns to his body and perished the next day, unfortunately. Um, the mechanic shop owner was charged with criminal negligence causing death, largely on some of the evidence by the worker who was working with the individual who had been fatally injured, and he had been previously convicted of a variety of criminal offenses himself, so there was some credibility issues there, and there was actually no evidence that the owner knew that the worker was going to use the torch to remove the tank. So he had no knowledge of how they were going to do it. He simply instructed them to do it, and he understood that the worker who was working with him was a trained and qualified mechanic. So although there were some indications that the shop owner had done something like that himself way in the past, the court found that there was no evidence that he told anyone in these circumstances that he was going to do it. So there was no direct cause indicating that the owner's instructions were what caused the death of the worker, and the individual who was actually doing the work would have known, um, or should have known, not to use an acetylene torch to remove it from this derelict Dodge Caravan. So ultimately, he was acquitted in those circumstances because he didn't direct them to do the work. So, and the fact that there was an accident waiting to happen set the context in the scene, but wasn't enough to form a conviction in this instance. So, uh, the owner was charged under OHS, though, under the regulatory provisions, and he ended up pleading guilty to three OHS um, offenses under that context. He was originally sentenced to a $17,000 fine, but that was increased to $57,500 based on a Crown appeal. So, see a low amount in terms of the actual fines that are imposed in these provinces, but the courts are still inclined to increase the fines after appeals. So that's one way to get around it in terms of the evidence. Um, Gooch, I think, is another case, and this one involved a fall from a height. And I noted that when I was listening to the pre-show before we got on, there was significant indication that SCSA has training on fall protection. This is one of those cases that involved some of that type of training in Nova Scotia. The case was largely about, though, evidence of some intoxication and evidence of the two workers who were with the individual who fell from a height. I think he fell from a height of about 19 or 18 feet. They were installing vapor barrier on a building. The individual who was fatally injured, his name was Brandon Alcorn. Um, the previous day, they had been doing the exact same same thing with the blue skin, and they were vapor burying certain components, the edges of the building and the roof itself. There was no need for them to actually be working within the 10-foot space between the leading edge and the area that they were working on the roof. And ultimately, Mr. Alcorn had been doing the same job the same way, the day prior. There was significant evidence of fall protection. Mr. Alcorn had been trained. He had presented his certificate to um, the owner of the work site and also his employer. I think the prime contractor was Maxim Construction in this case. There was very strong evidence of a safety program in place. The workers had executed a field level hazard assessment advising of the risk of falls. And the Maxim rule was you do not go within 10 feet of the leading edge. The regulatory rule was that you do not go within 6 feet of the leading edge. So they had exceeded the base requirements of the regulation. The worker had been given a harness, a lanyard, and an anchor. Um, Now the D-ring on the lanyard may have been damaged in the fall. There was some discussion about whether it was previously damaged or not, but they couldn't conclusively prove whether it had been damaged prior being given to the worker. But probably the most important fact is that the toxicology report after the accident indicated that the individual had 0.93 nanograms per milliliter of delta 9 THC in his blood at the time of sampling, which could have been greater at the time of his death. And ultimately, the court heard from experts who indicated there are no acceptable levels of delta 9 THC in a worker's blood when they're in a safety sensitive position like this. And um, some evidence had been heard by a person who did fall protection saying that he didn't know what intoxication looked like, and he was partial to the Crown's case in many ways. However, the experts indicated that walking backward off the side of a roof would be tantamount to an indication of impairment, and the court was inclined to believe them in that context. So the 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 defense that was raised was really that the impairment of the worker who was fatally injured was a brand new, unforeseeable intervening cause that was part of the defense that was raised, and ultimately the court concluded that that was correct. That severed any sort of potential action on the part of Mr. Gooch, who was the supervisor and the foreman, giving him instructions to do the work that day. So you've got a number of facts here. He was impaired. He showed up late that day. He had done the job the appropriate way the day before. He knew he wasn't to go to the leading edge, but he just simply walked backwards way too far on the date of his death. And ultimately, the court concluded that there was a severance of any sort of causation, and that wasn't conduct that resulted in criminal negligence causing death. So ordinarily, the court says a sober person wouldn't walk off the side of a roof. So this just gives you an indication of the importance of a drug and alcohol program and appropriate testing. They didn't they didn't test the two other workers. There wasn't any evidence of that, but presumably post-incident testing would have occurred and everyone would have been tested in this context, or at least that's the appropriate practice. And you'd want to find out, what was happening, whether it was a crew related issue or whether it was just an individual related issue. That plus the fact that the organization had a very robust health and safety program and that they had actually followed it were all very good facts, which led to an acquittal in this case. But another criminal negligence case for a foreman. Okay, well, I see I have a few minutes left. I'm going to switch gears here and talk a bit about prime contractors, owners, and control of a work site. Again, this is an area that's maybe changing a little bit. I had presumed that many of you would be familiar with the prime contractor regime in Saskatchewan. It's Part 33 of the OHS regulations. It was implemented in 2015, and it requires, in the construction context, that there be the appointment of a competent person and that there be a prime contractor appointed for safety purposes. And there's a variety of different requirements that range from hazard assessment to informational requirements to ensuring that the act is complied with. So that's the general regime. So if you're the owner, you're automatically presumed to be the prime contractor in Saskatchewan unless you delegate it in writing to someone else by virtue of a written agreement. So that's the backdrop. City of Sudbury is a case from Ontario where, although the legislation isn't exactly the same as what we have in Saskatchewan, they use the term constructor. There are some pretty important takeaways from the decision, and it casts a lot of doubt on the obligations of an employer in any context, even when they may have delegated prime contractor responsibility to someone else. So here, the city of Sudbury had contracted with a subcontractor to repair a downtown water main, and they had given total control over the site to Interpaving and appointed them the constructor. Now, during the repairs, an Interpaving employee using a grader had struck a pedestrian, and under OHS legislation in Ontario, anyone who enters a work site is potentially someone who needs to be taken care of. And the pedestrian was injured, and Interpaving was charged and ultimately convicted as an employer. But the city of Sudbury was also charged as an employer, and the reason is because it had sent quality control inspectors to the site. Now, under their legislation, quality control inspectors were permitted to attend, and just because an organization had quality control inspectors reviewing the site of a constructor that had been appointed doesn't mean that they then became the constructors. So there was a provision which prevented that from happening in the legislation. But the Crown got creative and charged the city as an employer because effectively the obligation in Ontario is based on employers. Every employer has an obligation to ensure the safety of other employers or other workers on the work site. It's a broadly worded provision that didn't have any sort of restriction with respect to any restriction with respect to control. So the city ultimately defends and says you can't charge us as an employer. You have to acquit us because that's not the way the legislation is designed to work. Otherwise, there'd be rampant obligations on every other party, even when we have very limited control over the circumstances and we have no ability to tell them what to do. Um, and at the end of the day, the trial decision found in favor of the city, but because of previous Ontario case law, the Crown appealed, and ultimately the Court of Appeal sided with the Crown and found that the city was an employer and was going to send back the case to assess the due diligence that the city had taken, either as a quality controller or as an employer in any context. So there was an appeal to the Supreme Court of Canada, and the Supreme Court of Canada, in a very divided court. There was 8 people who opined here in an unusual circumstance. You had one who had to recuse himself, Justice Brown, but 8 people opined. 4 were in favor of finding the city of Sudbury to be an employer, and 4 were not. So you had a court of equal division. In that circumstance, such a weird situation that relatively happens infrequently, the Ontario Court of Appeals decision then becomes the law. So what you have is the law being the law of the land in Ontario only. However, the comments of the Supreme Court are persuasive potentially in other provinces where there might be similarities in the legislation. There are some similarities in Saskatchewan, and there are many circumstances where it's not necessarily similar. Um, Ultimately, the the plurality, we'll call them the 4 that sided with the Crown's position to indicate that Sudbury was an employer, um, basically said that the issue of control has no determination on whether a party is going to be an employer under the act. That doesn't have anything to do with it. Control might have some implication on whether you exercise due diligence and whether you were able to exercise due diligence in the circumstances, but it doesn't really have anything to do with determining whether you are in fact an employer. If you had persons on the work site, you are an employer for all intents and purposes in Ontario. So then comes the dissent. The dissent says, okay, well, the provision that we're dealing with here, where you've got Section 25(1)(c), and you've got employers who might contract with other employers on the work site to do work, and those other employers may not be there at all or have any control. If we engaged in that, and if we allowed that to happen, what we would have, I'm sorry, I'll fast forward, what we would have is a situation where every employer would be obligated to ensure that everyone else who's on the work site is responsible and complies with all requirements of workplace safety. So effectively, everyone who employs anyone is responsible for everything that anyone does. And the court basically indicating here that this is far too broad of a requirement because it really muddles the obligations of occupational health and safety in the circumstances. So how do you know what one contractor is doing on a complete other component of the work site if you're just one small electrician doing some work in that area? That's a very difficult situation to be in. Yet the Ontario Court of Appeal, where the decision arose from, said that's the rule. um, the examples that the dissent put forward were I think very well constructed. They called the majority's approach, or I shouldn't say majority because they weren't. They're the plurality. There's 4 of them. They all sided together. They called it absurd. And some of the absurdities they pointed to, like on a construction site where you've got a catering company, that catering company could be potentially liable for a constructor's failure to install automatic limit switches to a tower crane on a site. That's how broad, because they're both employers. They both employ people. They both been contracted to do work at the same work site. So that that catering company is responsible for the tower crane operator now. In addition to that, owners might be dissuaded from sending quality assurance inspectors to a work site because if you send them and you've got employees on the work site, you might become an employer. That's a problem as well. This last example about homeowners being responsible for a contractor's subcontractors falling from a ladder may not necessarily apply in the context of residential construction in Saskatchewan. There's some exclusions in the context of prime contractor, but it could. So here we have some potential ambiguity in the law as a result of this decision. And I would suggest to you that there's probably going to be another decision that goes in front of the court another case that goes in front of the court at some point in time that hopefully clarifies the law on this, or at least maybe makes it a bit more certain as to what to do. And I look at this, we've got some takeaways for you. Um, Project site owners, they've got now, you're best suited to ensure that you take appropriate measures to ensure contractor compliance with legislation. So your due diligence measures, depending on whichever party you are on the work site, have increased significantly. And I think that, well, at least potentially increase significantly. So you might have to take measures to ensure that you've got appropriate measures in place to evaluate safety programs for contractors on site, monitoring contractors' work to ensure that they're performing work safely and with appropriate systems, and creating systems that you might have to actually enforce the safety requirements of the work site. So those are the types of things that I think a court post Sudbury might look at if there's this multiple employer type of charge that gets laid. And what's funny is we've seen some of that already happening in the context of OHS inspections. They're potentially utilizing provisions involving, greatest degree of control. This is what makes Saskatchewan a bit different. We already had a control type of element built into our regulations, which indicated that if the regs imposed a duty or requirement on more than one person, the duty or requirement is meant to be imposed primarily on the person with the greatest degree of control. And for a number of years, we've seen the Crown, I think, charge in relation to that type of understanding that, it's going to the person with the most control that likely gets the charge in the circumstances. And have seen, though, in inspections where there's some determination as to whether, okay, well, what about the prime contractor who's got this overlapping duty and one person fails? Then do you go back up the chain and go to the prime contractor? You'll see in a moment, I've talked about some prime contractor cases here where um, that the court has indicated that's the most important obligation at the work site. So there's some of that, and I see some potential for some disputes on this very point in this province coming to pass, and we'll have to keep our eye on it very closely. One thing I will say is that you look at the obligations of owners, though, and if the owner has delegated prime contractor status to someone else, and the activity occurring in the workplace that the owner owns but is delegated is not in their direct and complete control, then their obligations under the Act, I think, are mitigated to some degree. So it's almost like an impetus to say, appoint a prime contractor, but then step back from the overall review of the work site. This doesn't bode well for due diligence in any circumstances, because even if the owner has someone there and maybe comments on what prime contractor is doing or comments on subs, uh, there could be an argument that they're now in some measure of control of the work site. So it gets a bit convoluted. There are some defenses that are available to this, but City of Sudbury has made it difficult. Fire Sand Real Estate is the case that I was talking about, and I have here the indication of the parties that were involved. Ultimately, Judge Gray indicated that the largest responsibility for mitigating risk in the workplace lies upon the prime contractor. Um, so, in the circumstances, unfortunately, this didn't involve Right Construction as prime contractor. There was no designation here, and unfortunately, there was an accident that occurred when the owner brought their own forces onto the work site and had a crane hitting someone on a scissor lift. Ultimately, the judge gave a higher fine in the circumstances to the owner who had taken measures into their own hand and is actually acting as the prime contractor. So, why is it important? Again, because the potential consequences for um, conviction in Saskatchewan are large. We have very large fines. And if you are convicted of an offense, the maximum potential is $1.5 million as a corporation plus a 40% surcharge, and then supervisors can face $500,000 penalties. So you assume the responsibility of prime contractor, there could be potential liability there and potential risk. So it's important to pay attention to your due diligence measures, who's going to be in control, exactly what level of control parties are going to have, whether you're owner, prime contractor, or a subcontractor on the site. Those are important things. So I think I've talked about the overall responsibility here. Owner needs to be prepared to accept reputational economic risks that come with prime contractor obligations if they assume the role. And if they don't, there could be some other potential defenses. Now, I'm happy to take some questions in the time that we have left. I believe we've got about 5 minutes. So we'll look at common defenses for criminal negligence that might be successful. Well, we talked about one relating to the intervening act. That's the most important thing. I think that there's still some measure of determining what the appropriate standard of care is in the community, because it's not an intentional element. They call it a modified objective test, where there's some subjective components to the circumstances, but ultimately we're still looking at what the community would deem to be um, acceptable in the circumstances. You might be able to provide evidence of what is typically done in the community. In the fall protection case that I discussed, Gooch, one of the things the judge pointed out was the fact that occupational health and safety themselves, when they went up on the scissor lift to inspect something, there was an argument that was made that the organization hadn't even required the employees to tie off when they were on a scissor lift, but there was evidence that OHS in that province didn't even tie off when they were on the scissor lift. So that's one thing you could present in that context. And the other one being that OHS officers routinely saw people not wearing fall protection on roofs. Now, that's a dangerous one to make, but the court ultimately indicated it was a factor in determining what was reasonable in that community. So those are types of arguments that you can make in that context. And I would focus predominantly on the notion that either I didn't instruct them to do that specific thing, or I instructed to do that specific thing, but to do it safely, or that I had the appropriate training in the circumstances and I did everything I needed to do. So that's what those cases will come down to. Ultimately, the Crown has to prove their their burden on a reasonable doubt basis. I'm just going to read the question here. What happens when safety personnel has repeatedly made recommendations, but there's been disregard to adhere to these by a company if a dangerous occurrence happens? So this puts the safety officer in a very discomforting position. I would suggest in those contexts, if you make those recommendations, that as the safety professional, you need to ensure that they're completely documented. That would probably be the most important component of preserving your um, your hide, for lack of a better term, in the context of an investigation. If there's something that happens, those are things that are difficult. That's a question of safety culture as well. So the organization that you work with, if they continue to engage in that type of behavior, if they're, for instance, a contractor, you would you would turf the contractor if you're the prime contractor in that context, or at least you take significant measures to either sanction them in some way, or perhaps de-scope what they're doing to prevent them from doing something dangerous. It's difficult, more difficult when you work within the organization and you're feeling as though that you've got the inability to make any sort of statements to the ownership. The ultimate upshot of that might be that you have to resign if your concerns are not met and you fear for that. But what you need to do is ensure that you've documented your concerns in that context. Well, someone just asked what regulation change I'd like to see in Saskatchewan. That when there was an opportunity to comment on the occupational health and safety changes in this province back in 2020, I I took the opportunity to make some comments because I thought they were important. And there's some very unique and helpful provisions in other jurisdictions. There are two that I think I'd like to see. One would be in the context of accident investigations, where you're dealing with a statutory accident investigation following an incident. I would like to see those not being admissible against an accused in a trial. That would, I think, lead to perhaps more thorough investigations of accidents without fear of sanction or repercussion. I mean, you're still providing information to the regulator at some point in time, but that would be an important change. The other piece might be creative sentencing options, but that would require an entire infrastructure with which should deal with probation. In Alberta, for instance, there's the ability to have a judge sanction awards and penalties to organizations like yours, the counterparts in the Alberta context, which I find extremely useful. So if the money goes to an organization that's designed to enhance safety in the province as opposed to simply the government's coffers, I think that might be a useful thing in that context. So those are the two things that I think I'd like to see. Hopefully, I answered that. I will say thank you. I thoroughly enjoyed it, and if anyone has any questions for me afterwards, I'm always happy to answer them. Please feel free. You see my contact information on the screen. I hope you have a very successful conference, and I wish you all the best with the rest of it.
Well, thank you, John. From one legislation grew to another. I do appreciate it a lot. You had me at hello. I really enjoyed that entire presentation. It was beautifully presented, and I can't thank you much. I appreciate it.